The testimony of Judge James Hargis took place over many days in the courtroom of Judge Parker. He would answer each of his charges one by one. Would his denials of any knowledge of the alleged plot save him from the gallows? Come along with us as we walk through the testimony of Judge Hargis. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine for our flight back in time, but it convinces the YouTube algorithm that we need a bigger vehicle to reach more people who love history as much as you do. Now, back to our story. The Breathitt County News Report. First, we are going to finish off the article from the Breathitt County News, Jackson, Kentucky, April 28, 1905, concerning the Hargis trial. Quote, Tuesday morning, Jim Hargis went on the stand and denied every material allegation of the witnesses for the Commonwealth. Denied that Mose Feltner was ever in his office or that he ever wanted James Cockrill killed. He was subjected to a rigid cross-examination by Colonel Bronston and was on the stand all of Tuesday and Wednesday and had not concluded his testimony on Thursday morning at our last reports. Unquote. It is interesting that Hargis denies that Feltner was even in his office. And it is also interesting that at this point of the trials, he denies that he even wanted Cockrill dead. He will make contradictory statements concerning this in other trials. For reference, please see our other videos on the Markham damage case and the other Hargis trial videos. The Paducah Sun Report. The Breathitt County News did not give the reader very much detail about what went on inside of the courtroom during the testimony of James Hargis. We did find a more robust version of the events that took place over the course of several days in the Paducah Sun dated April 26, 1905. Quote, Empathetic denial by Judge Hargis. Declares he never conspired to kill anyone. Did feel bitter towards Tom Cockrill because Cockrill killed Ben Hargis, his brother. Mixed by cross-examination. Lexington, Kentucky, April 26th. Judge James Hargis on trial for the murder of James Cockrill took the stand as the first witness for the defense, and after the preliminary questions as to his birth, parentage, and education, the Cockrill killing was taken up. Hargis entered a general denial of the principal statements made by the Commonwealth's witnesses. He said that he felt bitter towards Tom Cockrill because Cockrill had killed his brother, Ben Hargis. Unquote. As we go back and look at what happened with the death of Ben Hargis, we remember that he had laid an ambush for Tom Cockrill in a saloon. The two had a shootout. Cockrill was wounded and Hargis was killed. It seems that the circumstances behind Ben's death did not matter to his brothers, only that Tom Cockrill killed him, even if it was deemed self-defense. Continuing on with the article and the testimony of Judge James Hargis, quote, he made the further sensational statement that he had stated openly that he would furnish any amount of money necessary to defend any man who should kill him. He said he had no feeling against James Cockrill, and Cockrill's father was a close friend. He denied Aunt White's statements that he, White, had been requested by Hargis to take the stand in the courthouse during Tom Cockrill's trial, and when a prearranged disturbance occurred, start to kill 5 men, among them James Cockrill. Unquote. This was a sensational point of the trial that needed to be addressed. That Hargis would disturb the court while in session to rid himself of an enemy. This would not be the first time that a witness or a judge was shot at and killed in the middle of a testimony. This also happened in Perry County during the French and Eversole feuds. However, Hargis was a judge and therefore knew better than to plot any kind of action. And if we believe the testimony of Vance White, then it would show that Hargis would go to any lengths to stay in power. Continuing on with the article concerning Judge James Hargis, quote, Judge Hargis swore that on the day when Cockrill was assassinated, he was asleep on a mattress in a room over his store shortly before the shooting. King Ford awoke to tell him Cockrill was in town. Hargis said that he expressed regret that Cockrill had come to town, as he feared that he and Kirk Jett would have trouble. Almost at this instant, the fatal shots were fired, unquote. The newspaper had made a typo. It is supposed to be King Ford, not Wing Ford. But let us suppose that Hargis is telling the truth about being asleep in the office. That does not address the plot or paying someone to kill the town marshal, James Cockrill. And why would King Ford need to wake him up to tell him that Cockrill was in town? For what purpose, if he was not to witness the shooting? And why would he fear that Kirk Jett would have trouble with James Cockrill? So far, we have not been able to find any direct reason why Jett would want to confront Cockrill. Was Judge Hargis afraid that his nephew could be injured or killed in self-defense by Cockrill, just as Ben Hargis had been? Continuing on with Judge James Hargis' testimony. Quote, after the firing, he said that Kirk Jett came up into his room, and also James Brophy and Doug Hayes. Hargis called across the street to Judge Fleenor and asked who was shot. Fleenor replied Cockrill had been shot, unquote. So, why did Hargis have to ask who was shot? He was in clear-eyed view of the place of the shooting. Was he, in fact, asking if Kirk Jett was also shot? Continuing on with the article, as there is a disturbance during the court session. Quote, at this juncture in the trial, the sheriff notified Judge Parker that a man was in the hallway of the court selling verses on the assassination of Markham. The court thereupon excused Hargis and the jury and called the verse vendor into the room. He was Henry Dunnigan, a mountain man, and he was reprimanded and dismissed, unquote. Now this is interesting. Verses back then were like pamphlets or flyers. Was Dunnigan on the side of Widow Markham, or perhaps hired by the Widow Markham to hand out flyers to everyone in the court? She could have done this to try to sway the jury for justice for the murder of her husband. She was still after the co-conspirators, even though the main men who did the killing were now paying for the crime. Finishing up the article concerning the Hargis trial. Quote, the examination was then resumed. Hargis said that Callahan was not in the room, nor was Alexander Hargis in Jackson that day. Hargis made sweeping denials of all the charges of the state witnesses. Hargis was cross-examined by the Commonwealth today, and some of the questions caused him to make answers contrary to his direct testimony, unquote. As we finish out the testimony of Judge James Hargis in this article, we see that he continued his denials of the accusations that were leveled against him by the Commonwealth's witnesses. But on the cross-examination, he made statements that contradicted himself. We do not know if these statements were enough to charge Hargis with perjury. However, we could not find where Judge Parker charged him with anything after he left the stand. Defense witness James Hargis. It seems that the Commonwealth had finished with its line of questioning of Judge Hargis. Before he left the stand, Hargis would make a sensational statement about his innocence of the crime for which he was charged. According to the article found in the Hopkinsville Kentuckian, quote, Hargis desperate makes an impassioned personal appeal to jury. Lexington, Kentucky, April 28th. When Attorney Bronson had concluded his cross-examination of James Hargis at Lexington, the accused made a dramatic statement to the jury, claiming to be innocent of the charges against him. Hargis said to the jury, quote, I want to say to you 12 gentlemen that although I have been on the witness stand for over 2 days, My attorneys have not asked me whether I was innocent or guilty of this charge. I want to say to you that I am innocent, and if I were guilty, I would not ask that woman to call me husband or that child to call me father." Unquote. The last part of the statement was made with both hands pointing to the wife and daughter of the accused, both of whom were sitting just back of the defense counsel. Unquote. What a statement! Hargis is trying to say that the crime of murder is an act that a married man with children would never do. That by being a good husband and father proved that he was innocent of the crime. This is a straw man argument. A straw man argument is when a person wants to prove that their perspective is superior to an opposing argument. That by saying that he was a good husband and father, that alone would make him innocent of all the charges that were leveled against him. That it would be impossible to be both an outlaw and a great family man at the same time. Hargis is giving the argument that basically if you are a bad person, then you are a bad person to everyone who knows you regardless of relationship. This is not necessarily so. There are many cases of family members of serial killers, such as John Wayne Gacy, for example, not a comparison, that acted completely normal, loving, and functional to his family, while being a serial killer out in the world. The Mount Sterling published an article which picks up after the testimony of Judge James Hargis. We gather from other reports that there were witnesses to take the stand after Hargis to impeach the testimonies of the Commonwealth's witnesses. Quote, Hargis trial. The fourth week began on Monday. James Hargis had a lengthy examination last week denying nearly all testimony of witnesses against him. Strong efforts were made to impeach the witnesses against Hargis. Alex Hargis on Saturday denied knowledge of conspiracy involving his brother. The case will probably consume all of this week. Unquote. In the Mount Vernon Signal, we read an interesting version of events. Quote, the testimony of the defense in the Hargis case at Lexington was closed Monday, and the Commonwealth began the introduction of rebuttal testimony. The accused was put on the stand and made an important statement, which the next witness contradicted. Alex Hargis denied any connection whatever with the Cockrill or Markham murders. The contempt rule against Brett Combs was dismissed. Unquote. While we will get to the testimony of Alex Hargis a little later in this story, and the controversy that Judge Brett Combs will find himself in, we do find it interesting that the next witness on the stand will contradict Hargis in his testimony. The second defense witness, S. King Ford. According to the Hargis testimony, this is the man who was in the room with Judge Hargis and woke him up from his nap to tell him that Town Marshal James Cockrill had returned to town. But Willie testified to the exact same events. According to the Breathitt County News, quote, the Hargis trial. After Jim Hargis finished his testimony, King Ford was next placed on the stand, who testified that he was in the Hargis store at the time of the shooting, and that Jim did not have any gun, unquote. So, according to the testimony of King Ford, Jim Hargis did not have a gun in his hand when the shooting of Cockrill had taken place. But did he wake him up from a nap, or was Jim Hargis already awake? Why was King Ford in the room in the first place? Did they expect an event to happen? Ford's testimony would not go unchallenged. It seems that King Ford was up for contempt charges in Letcher County at that time. We could not find any record of the trial that had taken place that involved the testimony of Ford. But we can gather from the article that one did exist. According to the Hopkinsville Kentuckian, quote, King Ford, the principal witness for the defense, testified, and then Colonel Allen for the prosecution produced a copy of an indictment against Ford, charging him with obtaining money by false pretenses in Letcher County. A rule for contempt of court was issued against Brett Combs, acting judge of Breathitt County, charged with attempting to intimidate a state witness and will be heard by Judge Parker, unquote. Since this article also addresses what happened with Honorable Brett Combs, we will take a moment to explain why his case was brought in at the same time as Ford. The case of Honorable Brett Combs. Evidently, charges against Brett Combs was being leveled against him during the defense portion of the Hargis murder trial. It is unclear if Combs appeared before Judge Parker during the Ford testimony or afterward. However, they were close together, and the newspaper made mention of this by linking the two events taking place in the same article. We now have more information about the charges against acting Breathitt County Judge Brett Combs. Combs was acting in the place of Judge James Hargis while he was facing charges of murder and conspiracy to murder. But it seems that Combs could not stay out of trouble himself. He would be brought up to face Judge Parker on charges of attempting to intimidate a Kentucky state witness. We did find out what the charges were about. It simply boiled down to a threat made by Judge Brett Combs while he was acting as judge for Hargis. Warning, this does contain strong language. According to the Daily Public Ledger, quote, James Hargis, county judge of Breathitt, and incidentally a member of the Democratic State Central Committee, when asked if he would resign, said he would, quote, do as he damned pleased, unquote. And the Honorable Brett Combs, who is filling Hargis's seat on the bench while the latter is on trial at Lexington, says that those who testify against his friends, quote, ought to have their damned heads shot off, unquote. Evidently, Breathitt County has produced a damn fine lot of judicial timber, unquote. We have to give credit where it is due. Judge Parker was not about to put up with anyone running interference in his courtroom, especially an acting judge. So Parker forced Combs to face him in his courtroom to answer the charges of trying to intimidate a state witness. As we have stated earlier in the Mount Vernon Signal article, these charges would be dismissed against Combs. But we can just imagine the scolding he received from Parker for making such statements. Returning to the S. King Ford's testimony, we find in the newspapers an interesting statement made by S. King Ford about the personality of Judge James Hargis. He felt that you couldn't scare the judge, and that he was completely innocent of the crimes for which he was charged. According to the article in the Mount Vernon Signal, quote, Colonel S. King Ford of Cynthiana, one of the star witnesses in the Hargis trial at Lexington, said, quote, Judge Hargis has perfect faith in his acquittal, unquote. Said Mr. Ford, quote, and I myself believe that he will come clear without any trouble. The judge is a man of imperturbable nerve, and you couldn't scare him if you pointed a loaded cannon at him. I believe that he is entirely innocent of the crime imputed to him, and that the jury will so decide. The trial will probably continue most of the week, and there is yet a number of witnesses to be examined, and long arguments to be heard from both sides, unquote. It is interesting that Ford would say that he felt that Hargis would be exonerated of the crimes, that he felt that the jury would side with Hargis, that he could not have killed Cockrill. However, other than attacking the witnesses for their shortcomings in life, there has not been any evidence to the contrary that he did not participate in a conspiracy or plot to have Cockrill killed. As the Breathitt County News reports, this is the most complete section of this trial that we could currently find. More may come to light as digital conversion from the older newspapers and other information such as court documents become available online. But for now, this is what is given to everyone for the defense witness wrap-up. The May 5th, 1905 Breathitt County News article will be used in this section. Quote, James Brophy was next introduced and testified as to what was happening about the time of the killing. Several witnesses were then put on the stand for the purpose of impeaching Mose Feltner and Jeff Smith, two important witnesses for the Commonwealth, but several of them had to admit on cross-examination that their own characters were not above suspicion. Alex Hargis was the last witness for the defense put on the stand, who made a general denial of any connection with the conspiracy to kill Cockrill or anyone else, unquote. Sadly, we are not given the testimony of James Brophy. This would have been a true find. It leaves us wondering, what did Brophy say that was contradicting Hargis and Ford? What did he know? Why was he testifying for the defense instead of for the prosecution or as a rebuttal witness? Did his testimony impeach Hargis and Ford? Was he himself impeached because of their testimony? We simply have not been given any clues. Hopefully, time will reveal what he said on the stand. We also see that the defense felt that the testimony of Mose Feltner was very important. They brought several witnesses to impeach his testimony. However, it seems that upon being cross-examined, their own characters did not bear weight, as they themselves were often on the other side of the law. Because of their reputations, it seems that their testimonies against Mose Feltner needed to be taken in that context. The last witness in this section of the story was Alex Hargis, who would deny ever being in the town of Jackson when the shots were fired that killed Town Marshal Cockrill. He would also deny wanting to kill Cockrill or anyone else. His testimony would be the last of the defense. And so now the defense case is closed, and now begins the rebuttal witnesses for the Commonwealth of Kentucky. Quote, the Commonwealth then introduced several witnesses who were residents of Leslie County, the home of Moses Feltner, and were leading citizens, and many of whom were officers or had held office in that county, who testified that the reputation of Moses Feltner as to truth and veracity was good, but that his moral character was bad, in that he had been accused of moonshining and getting into fights, unquote. So the Commonwealth comes out swinging when it comes to protecting the testimony of Moses Feltner. With the rebuttal witnesses, the prosecution is sort of conceding that Moses is not the most upright moral of characters. However, they are putting people on the stand that even though he is a moonshiner and does get into a lot of fights with people, this does not say that he is a liar. That those facts about Feltner are completely different from each other. The next rebuttal witness placed on the stand would defend the reputation of Jeff Smith. It is interesting that out of all the witnesses that the Hargis faction had to come against, that it was the testimonies of Smith, White, and Feltner that they worked the hardest to impugn. Quote, several leading citizens from Breathitt and Wolfe counties testified that Jeff Smith's reputation for truth and veracity was good. Several witnesses were there for the purpose of sustaining Ance White's reputation, but the defense objected to their being introduced on the grounds that they had not tried to impeach him, but had only contradicted him, unquote. Uh-oh, we have an objection in the court concerning the testimony of Ance White. So what is the difference between impeaching and contradicting someone in court? They seem the same thing, right? Well, actually, there is a difference between the two. Impeachment of a witness refers to the process of discrediting them during the trial. This is usually done during the cross-examination to reveal their bias and or falsehood in their statements. This can also involve contradicting statements, but more evidence needs to be presented for impeachment. Contradiction is when a witness says two different statements in the same testimony that contradicts each other. This is different from inconsistent statements made outside of the court proceedings. So what the defense was trying to say is that they did not try to impeach Ance White, only try to show that his own statements contradicted each other. Therefore, the other witnesses were not needed or warranted in the trial evidence. We do not have a ruling about the objection. The Mount Vernon Signal Reports. Somewhere in the middle of the rebuttal witnesses, we find the testimony of Kurt Jett and Rufus Lyle. Jett had stood trial for the murder of Town Marshal James Cockrill, and Lyle was a banker whose testimony concerning Moses Feltner was critical. According to the Mount Vernon Signal, dated May 5, 1905, quote, Kurt Jett, convicted of the assassination of James B. Markham, was taken from the Frankfort Penitentiary and testified in the Hargis Conspiracy case at Lexington. He refused to say anything that might incriminate him or anyone else. Rufus Lyle, a clerk in the Winchester Bank, testified that the president and cashier of the bank were away from Winchester, and he knew nothing of the note executed by James Hargis. The court issued an order for him to produce all of the books of the bank bearing on the note. More witnesses in rebuttal were introduced, unquote. Kurt Jett's case was currently running through the Kentucky Court of Appeals. While he was found guilty of the crime of first-degree murder, he was hoping to have the decision overturned. He was not about to say anything that could jeopardize his chances with the appeal court. He was also not going to say who did what when it came to the plot surrounding the killing. Concerning the testimony of Rufus Lyle, even though he said nothing about what the money transpired concerning Judge Hargis could be used for, he would still be ordered to bring in the bank records so that they could be examined. This was very important because everything that Moses Feltner testified to in the case was concerning how he was paid off in the Markham trial to leave town with many witnesses. There was a paper trail if these statements were true, and they needed to be brought before the judge and jury for examination. Closing arguments. While we do not know what was said during the closing arguments of the case, we do have who stood up to speak on behalf of the two sides of the case. The May 5, 1905 Breathitt County News reported the following. Quote, both sides closed Wednesday at noon, and the afternoon was taken up in arguing on the instructions. The arguments on the case were begun Thursday morning. George Hunt made the first speech for the defense and was followed by B.F. Byrd for the Commonwealth, followed by E.P. Farrell for the defense, C.J. Bronson for the plaintiff. J.R. Lee will make the closing argument for the defense, and Colonel John R. Allen, blank, prosecution. The next sentence is unreadable, unquote. So the order went defense, prosecution, and so on until the prosecution had the last argument to give. Because there were holes in the newspaper because of time, we are still able to read just enough to find out who were the attorneys for each side of the case. We will now move forward to the jury instructions. Jury instructions. It would seem that the judge's jury instructions were not up to par. This would cause a lot of upheaval in Breathitt County. The Commonwealth's attorneys would take their displeasure of the court's instructions to the appellate court. But for now, let us see exactly what the upheaval was about. According to the May 12, 1905 Breathitt County News, quote, the Hargis case. Judge Parker surprised the whole country on last Thursday when he refused to instruct the jury to find against James Hargis for being an accessory before the fact in the assassination of James Cockrill. Nobody has ever claimed that he fired the fatal shot, but it was the contention of the prosecution that he counseled, advised, and encouraged those who did. And it seems that they proved beyond a reasonable doubt the truth of their allegations, but when the evidence was all in, they were dumbfounded when they found that the judge practically instructed them out of the court, unquote. This was shocking. In one fell swoop, Judge Parker had turned a conspiracy case into a murder case. There would be no evidence that Judge Hargis shot anyone. However, there seems to be an extreme amount of evidence that he masterminded the plot and participated in a cover-up after the fact when Town Marshal James Cockrill was killed. In the May 6, 1905 Daily Public Ledger, we get a little more information as to the reasoning that Judge Parker had about the jury instructions. Quote, a sensational turn was taken in the Hargis case at Lexington Thursday, when Judge Parker refused to instruct the jury for accessory before the fact, on the ground that this offense was not properly charged in the indictment. The only chance for conviction, many believe, lies in the fourth paragraph, which declares that if Cockrill was shot by some person other than Hargis, and Hargis was at the time, quote, so near to such a person or persons that he could give him or them aid or assistance in doing such shooting, unquote, or could, quote, aid him or them in escaping detection or evading or resisting arrest, and if the defendant was in such a position for the purpose of this part of giving such aid or assistance, unquote, then Hargis can be found guilty, unquote. Wow. Let's break that down, shall we? Basically, Judge Parker's instructions to the jury can easily be read as if Judge Hargis was not standing beside of or in the same room with those that shot Cockrill, and if he did not render any aid for escape or helping to hide said shooters, then he must be found innocent. This is after the fact. Again, the trial was about the events that took place before the shooting, not after the shooting. While history will leave very little room for question upon the guilt of Hargis, for now it seems Judge Parker would be in his corner with the jury instructions. Judge Parker would have to defend his stance in the Hargis case. According to the May 12, 1905 Mount Vernon Signal, quote, Judge Parker made an address in the courtroom in which he defends his course in the case, declaring that, from a standpoint of law, the instructions to the jury were so simple that even children could understand them, unquote. So, Parker was hiding behind a standpoint of law when he was making the jury instructions? The May 12, 1905 Breathitt County News article is very long. However, it basically boils down to how the citizens of Breathitt County reacted to the jury instructions. They held high hopes that Judge Hargis and his faction would finally meet justice, that Judge Parker would give them relief from what the law-abiding citizens of Breathitt County felt was a huge miscarriage of the justice system. They now felt that after all the expense of several trials, that this case was not allowed to stand on its own merit. The verdict. The verdict of the jury was no surprise. After all, Judge Parker just handed the defense a huge gift. But would the jury completely agree with him? It would seem that two of the men of the jury did not. According to the Mount Vernon Signal on May 12, 1905, quote, after a second declaration to the court that agreement was impossible, the jury in the Hargis case at Lexington was discharged. 10 of the jurors were for acquittal, and 2 of them refused to be charged from the belief that he should be convicted. He was ordered back to jail, and a motion for bail, argued by the attorneys, was passed upon Monday morning. No surprise was caused by the outcome of the trial, as under the instructions of Judge Parker, no one looked for a conviction, unquote. We get a little bit more information about how long the jury deliberated in the May 12, 1905 Mount Vernon Signal. Quote, hung jury in the Hargis case. In his instructions, Judge Parker made no reference to a conspiracy. The case was given to the jury on Friday night at 9 o'clock. On Saturday morning, there was no prospect for an agreement, and at 2 p.m. the jury was dismissed. They from the first ballot stood 10 for acquittal, 2 for conviction. Application was made for bail, unquote. To further the evidence for a hung jury, Judge Parker polled the jury. We get more information from the May 11, 1905, The Citizen. Quote, Judge Hargis trial. The jury failed to reach an agreement and were discharged. Lexington, Kentucky, May 8th. James Hargis, the county judge of Breathitt County, who had been on trial for 4 weeks for complicity in the murder of James Cockrill, is still prisoner in the Fayette County Jail, although the jury in the case failed to reach a verdict after deliberating 15 hours. The jury announced to Judge Parker that they had failed to reach an agreement and asked to be excused from further deliberations. Judge Parker questioned each juror separately, and after each had said that it would be impossible to reach a verdict, Judge Parker discharged them, unquote. So, because of the instructions that Judge Parker gave to the jury, they were unable to agree on a verdict. This would set up for a possible retrial for the case. However, the Commonwealth was not done. They would appeal the jury instructions to the Appellate Court of Kentucky. The Hargis case continues. To say that the Commonwealth attorneys were not happy was an understatement. They felt that Judge Parker threw the case for the defendant. A term that is no longer used is, quote, passed upon, unquote, and you will hear it a lot in these appeals processes of the case. It simply means that the attorneys are exercising their right for the case to be reviewed by the appellate court concerning the lower court's decisions. In other words, Judge Watts Parker's jury instructions were not as the Commonwealth felt was fair according to the indictments, and they wanted the testimonies from those in Wolfe and Leslie counties that were denied to be let into the case record. The Interior Journal reports, May 16, 1905, quote, Commonwealth's Attorney Allen of Lexington will ask the Court of Appeals to pass upon the legality of Judge Parker's instructions to the jury in the James Hargis case, and also upon the right to reject certain testimony which was not allowed, unquote. This was very important, as the decision on whether or not to retry Judge James Hargis for the crime of conspiracy to murder hung in the balance. We get more details of this from the Mount Sterling Advocate, May 17, 1905. Quote, Colonel Allen asked for a higher tribunal to pass upon instructions given by Judge Parker in the case against Judge James Hargis. On Thursday, the Commonwealth in the James Hargis case, represented by John R. Allen, appealed from the decision of the Fayette Circuit Court. The higher court will be asked to pass upon the legality of the instructions given in the case. This proceeding is seldom resorted to by the Commonwealth. It is in accordance with the provisions of the Code, which gives the Commonwealth the right, in cases of mistrials, to have the Court of Appeals pass upon the instructions and upon the competency of testimony admitted or rejected by the trial judge. The Commonwealth, in asking for this appeal, which was granted by Judge Parker, realizes the odds against the conviction in any of the cases under the instructions. It announces that it desires to have these serious legal questions decided by the higher court so that further time and labor and expense of mistrials may be avoided. If the instructions given by Judge Parker are held to be valid, it is probable that the cases will be remanded to the grand jury and another indictment drawn, which will permit an instruction covering accessory before the fact, unquote. So, it depended upon who the appeals court agreed with on this decision as to what would happen next to the case. If they agreed with the Commonwealth attorneys, then the actions of Judge Parker could not be done in future cases, and it would help juries to make better decisions and relieve them of being deadlocked. If the appeals court decided to agree with Judge Parker, then the Commonwealth would have to take its case back to a grand jury and have another indictment issued for the case. There were other cases behind this one for the same charge of conspiracy, and how the appellate court would rule would affect those cases under the current indictments and could lead to the Commonwealth taking each case before a grand jury for a new indictment. Because of this, we will see what happens to their cases next. According to the Daily Public Ledger, The cases of James Hargis, Alex H. Hargis, and Ed Callahan, charged with conspiracy in the murder of James Cockrill, and docketed in the Fayette County Circuit Court, which opened Monday, will probably be continued, pending a ruling of the Court of Appeals in the James Hargis case, unquote. So, now several cases were just tossed up into the air because of the actions of Judge Parker. The Commonwealth now had a decision to make. Either they had to let the defendants go until the appeals court ruled on this matter, or try to go ahead and roll the dice and try their cases now. Bail granted. Judge Parker basically told the Commonwealth attorneys to try the cases or to let them go with bail. Going back to the Mount Sterling Advocate, May 17, 1905. Quote, other cases passed. The cases against the other defendants were called Thursday and passed until Tuesday. Judge Parker indicated that in the event the cases were not tried, he would grant the other two defendants bail. The Commonwealth announced that it would elect to try Edward Callahan next, unquote. Basically, Judge Parker just put the Commonwealth on a clock. They could not hold the defendants in jail forever. They had the right to be tried in a timely manner or set free on bail. Instead of waiting on the appellate court, the Commonwealth decided to go ahead with its other cases. But there is now a question about Judge James Hargis. Would he be set free, placed on bail, or remain in jail because the jury could not make a decision? In the article found in the Mount Vernon Signal, May 12, 1905, quote, in the state, Judge Watts Parker of the Fayette Circuit Court Monday admitted James Hargis to bail in the sum of $25,000. The bond was signed by Floyd Day and J.C.M. Day, wealthy lumber merchants of Jackson, and M.C. Courtney and John M. Stevenson of Winchester, unquote. The first to go out on bail because his case had been tried and the jury could not make a decision on the matter was Judge James Hargis. It could take years for the appellate court to make a decision on the case. And so, Judge Parker set his bail, and after it was paid, released him. Now, $25,000 back then was not the same as today. As of August 2024, the conversion is $1 in 1905 is the equivalent to $35.70 in purchasing power today. So the bond set for Hargis could be read as a value of $893,579.55. That would be a huge chunk of change to come up with all at once today. That is why Hargis went to both Days, Courtney, and Stevenson for help with the money needed to make bond. An agreement had to be reached concerning the cases of Elbert Hargis and Sheriff Edward Callahan, because their cases also hinged upon the verdict of the appellate court. According to the Interior Journal, May 16, 1905, quote, as the result of an agreement between counsel for defense and prosecution, Judge Parker at Lexington admitted Elbert Hargis and Ed Callahan at Breathitt County to bail in the sum of $10,000 each and continued their cases to the fall term of the Fayette Circuit Court, unquote. As we have already explained how the inflation calculator works, $10,000 in 1905 would be worth $357,431.82 in today's currency. And now those cases would be heard in the fall term of the year of 1905. We searched for the appellate court ruling upon this matter. We did find that a year after this case was put before them, the appellate court still had not ruled in the cases, and that Colonel Allen stated that they would continue on forever if needed. We can surmise that these cases were dismissed in 1908, when the first defendant, Judge James Hargis, and the second defendant, Jesse Spicer, were both killed. We can reasonably give this guess because the cases against the other defendants were dropped after the Hargis death. According to the Interior Journal, October 9, 1908, quote, in the Fayette Circuit Court, the cases of Alex Hargis, Elbert Hargis, Ed Callahan, and Jesse Spicer, charged with complicity in the assassination of Town Marshal James Cockrill at Jackson 5 years ago, which had been on the docket for 2 years, were ordered dismissed and stricken from the docket, unquote. This is the last trial we will cover in the Bloody Breathitt County series. There were several other trials in several different counties, and all of them resulted without a conviction for conspiracy. Only those that could be found with a smoking gun in their hand were found guilty of the crimes. The rest of the faction, rightly or wrongly, were never convicted. And now, it leaves open the question, were they guilty or innocent of the crimes of conspiracy in the murders of Cox, Markram, and Cockrill? What happened to the feudists? While there are many people involved in this feud, we will go over what happened to the main characters that were charged with conspiracy to murder Cox, Cockrill, and Markham. All source information about them is found in the description box under websites below. Judge James Henderson Hargis would be shot and killed by his own son Beach Hargis on February 6, 1908. The two men had an argument in the Hargis General Store when the shooting occurred. Several more trials for conspiracy to murder would take place against Hargis for the murders of Cox, Cockrill, and Markham in several counties, of which he would be acquitted of all charges against him. However, the Markham damage case of the appeals court did rule with Widow Markham, and Hargis was found liable and had to pay her damages. Judge Hargis was 45 years old at the time of his death. Kentucky State Senator Alexander Hamilton Hargis would die in Lexington, Kentucky on April 30th, 1943, at the age of 83 years old. He would be acquitted of all charges against him. Elbert S. Hargis would die in Fayette County, Kentucky on September 4th, 1940, aged 65 or 66 years old. Edward Ned Callahan would die May 11, 1912, shot in his bed in Buckhorn, Perry County, Kentucky. He would die shortly after making a peace treaty with Captain Strong, who he was also feuding against. There is more information available about this in our Strong-Callahan feud video. Benjamin Fulton French was also of the French-Eversole feud. He was shot in 1913 by Harry Clay, One-Arm Harry Eversole, when French met Joe Eversole's widow Susan and Harry on the street. French said, quote, "Good morning, Mrs. Eversole," unquote, when Eversole took out his pistol and shot French in the spleen. French would die of this wound in 1915. Jesse Spicer, also known as John McHenry Spicer. He was embroiled in a federal land case concerning fake land deeds. We found this article concerning the death of Jesse Spicer. According to the Find a Grave website, his real name was John McHenry Spicer. Born February 8, 1872, and died May 4, 1908. If true, he would have been the second of the feudists to die before the case was decided. According to the newspaper article on the site, there was a family quarrel over a potential divorce between Ed Callahan and his wife, who was sister to Jesse Spicer. Spicer and Callahan had an argument that came to blows when Spicer attacked Callahan with a knife and almost cut off his arm. Callahan's 17-year-old son, Wilson, came to his father's defense and shot Spicer through the heart, killing him instantly. And so ends the Bloody Breathitt County feuds. Thank you. We at Kentucky Tennessee Living would like to thank you for watching our video series on the Appalachian feuds. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. Be sure to double check that you are subscribed, as some of our viewers are finding that they are no longer subscribed to our channel. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.